Welcome to selecting the right legal entity for your startup. My name's Laura Good, and I'm with Startup SAC. Startup SAC organized this workshop, and we're all about accelerating Sacramento's startup and innovation economy in the greater Sacramento region. So I would welcome you to check out our website if you haven't, at startupsac.com. There's lots of information about resources that are available in the region, not just resources that Startup SAC supports, but ones from everyone in our region who helps entrepreneurs. So Startup SAC is a nonprofit, and I just want to give a shout out to our sponsors who make this workshop, as well as our website and everything Startup SAC does, possible. They are SMUD, Witten Law, Bender Insurance Solutions, Minetta Ventures, Stoll Reeves. Our speaker today, Justin Borrowdale, is with Weintraub Tobin, Cap City, Digitally Driven, 3 Steps Forward, the Metro Business Center, and Ernst & Young. So I'm just going to play a short video from SMUD. Can you guys still see my screen?
Yeah.
At SMUD, we're committed to zero carbon by 2030. We're creating more energy from renewable resources, reconfiguring our power plants to improve air quality, electrifying our fleet, greening our buildings, and accelerating clean energy with our first grid-scale battery farm. The Clean Power City movement is happening. For 37 ways you can join the charge, visit cleanpowercity.org.
Sorry if you couldn't hear that. I forgot to do the little thing on Zoom where you say to share your speakers too. So, okay. All right, so if you are have just joined us during that, you're here for selecting the right legal entity for your startup. Our presenter is attorney Justin Borrowdale with Weintraub Tobin, and I am going to go ahead and stop sharing my screen and invite Justin to share his, and we'll get right into the meat of things.
Excellent. Thank you so much, Laura. So you guys should have my screen now.
Oh, I forgot to say about the questions. If you have questions during Justin's presentation, type them in the chat. If it's, we prefer to wait till the end of the presentation to answer questions, but if you have a question about something that he's explaining right at that moment, we'll go ahead and take it. So, all right, Justin, we're ready.
Perfect. Thank you. So like Laura said, we're going to be talking a bit today about selecting the right entity for your startup. Thank you for taking some time to learn about this with us today. So I'm a senior attorney at Weintraub Tobin. Weintraub is a business-focused law firm that started in Sacramento, but now has offices throughout the state. We've got offices here, San Francisco, Los Angeles, Newport Beach, and San Diego. And I work in our corporate transactions group. So basically that means I work on a lot of business transactions, no litigation. And that usually takes the form of, entity formation, financing, working on commercial agreements like a license agreement, securities regulation issues, and mergers and acquisitions. And all of those things tend to tie in with startups, and they're a little bit more specific for startups than a mature company, but work with startups on those items regularly as well. Weintraub also has other specialists. We've got tax folks, real estate folks, employment specialists, and God forbid, litigators if you need them. So we have all those options available. And then before we jump into the meat of things here, I wouldn't be a good attorney if I didn't read my approved disclaimer about this presentation. So get that out of the way now. So the presentation of these materials does not constitute legal advice, and it does not establish an attorney-client relationship with the presenter or with Weintraub Tobin. Advice for specific legal issues should be sought from your properly licensed legal counsel and not by reliance on this presentation or these materials. And with that, we can jump into some more interesting things here. So obviously we'll be covering, the choice of entity. There's a number of different aspects that play into what entity you decide to go with as a startup. And we'll work through these different entity types, get some background on them, how they compare to each other, and that will lead into what makes the most sense for most startups. Having that baseline understanding of what we're talking about will be really helpful here. And so we've got the different entity types, corporation, LLC, limited partnership, general partnership. Sole proprietorship is not really an entity type, but it falls into this discussion. So you've got those entity types that you're looking at, and then you're going to have other considerations besides the entity type to factor in as well. So you've got taxes, ownership limitations, costs, administrative burden, state of incorporation, and all of these things you're going to be looking at sort of in total and weighing different factors depending on your setup, what makes the most sense for you, and that will lead you down, hopefully down to a clear path of what entity you should be going with. I did want to point out that there's a number of other sort of ancillary entity types that don't really apply here, so we won't be covering them, although they do exist. Limited liability partnerships, professional corporations, those are limited in scope. Those really only apply to a law firm, medical provider, those sorts of things, so don't really come into play here. Similar with nonprofit corporation or a trust or other unincorporated entities. See, there we go. So we'll sort of take these things backward from the most simplistic up to corporations and LLCs. So first, I wanted to talk about sole proprietorship. So this is basically a default if you decide not to do anything. You don't really put any thought into it and don't decide to form an entity. If you're sitting in your garage making widgets and you decide, hey, I'm going to sell these widgets, I'm going to get an Amazon account and sell these widgets to people, that's basically a sole proprietorship. It's just you deciding to go into business to start this thing. And so that's obviously pretty easy. You don't have to do too much to sort of form that entity. It just happens by default. Of course, you have to get a bank account and a business license, and there's other things you have to add on to it to actually run the thing. But for entity purposes, the sole proprietorship is formed just by sort of going into business for yourself. So obviously that's really easy, and there's got to be more to it than that. Otherwise, we wouldn't have an hour-long presentation about selecting an entity. So the limitations of having a sole proprietorship like that, the first real big one, obviously, is liability. So when you create a sole proprietorship, you are taking on just general liability for the acts of that business. So by way of example, say you're making your widgets, you sell one to me, and there's some issue with it, and I cut my hand off. I'm going to sue you. I'm going to sue the business for the damages for cutting my hand off. Because this is my hypothetical, I'm going to win, and you owe me a bunch of money. So in this situation, you're a sole proprietorship. You are the business. So I sue you as an individual, and now you are liable for the damages that I've suffered. So that means I can go after your house, your car, your bank accounts, all of those sorts of things. Obviously, that's a bad situation and not how you want to have things set up. You want to confine the liability of the business to the business. You don't want your personal assets to be at issue here. And so that requires some thoughtful analysis in how to set up an entity and actually do something rather than default into this sole proprietorship. Similarly, a general partnership has those same issues, right? A general partnership is formed by default when two people are coming together to operate a business, right? So in this expansion of the first hypothetical, it's somebody that's making the widgets, and they say to their friend that's a salesperson, say, hey, I want to form this business with you. I'll make the widgets, you sell them, we'll run the business that way. That by default is a general partnership. Similar to the sole proprietorship, the two general partners have unlimited liability. So, any act of one general partner reflects on the others. And now, expanding out to my litigation scenario, I'm suing the company, I'm suing the business for the damage to my hand. That means I'm going to sue both of you, and I'm going to go after both of your personal assets. So again, we have those liability issues that you run into when you fall into one of these default entities. Let me see here, make sure I'm not skipping anything. Yeah, so the general partnership, you can expand on that a little bit in terms of how you want to set things up and how it would be governed, right? So sole proprietorship just is what it is. General partnership, you can default into it, but you can also add some layer of control, management, corporate governance, all those sorts of concepts on top of it through a partnership agreement. And that's the next complication in this setup, right? So you've got the liability issue, then you've got the control and management. If there's a single person, then you really only got the liability to worry about, because it's just going to be you operating everything, so the control is less of a problem. But for a partnership, you've got somebody else that you're having to work with. And if you guys are just working in your garage and setting this thing up, there's default language that governs how that's going to work, but there's holes in that default language that's just found in statute, and it's likely not going to be how you guys would really want it to be set up. If one of you is contributing more time and effort, maybe they're supposed to get a bigger percentage of the ownership of the company. Maybe they're supposed to have more control over how the company operates. All of those things are going to be lost if you're just relying on the default. And so that's the other area where some thought should be paid to how this thing is set up, how it works, and then documenting all of that so that there's a clear understanding. This is how it's formed. This is how it's going to operate day to day going forward. And then, the other protection is on the back end. You want to make sure that if this thing falls apart, if the company doesn't do well, if one of the people, is no longer interested or can't devote the same amount of time they were planning to devote when it first started, how do those things shake out? What happens in those scenarios? And so that's all part of this entity selection, is figuring that out, picking a path and going forward, because it makes more sense to do all this stuff when you're starting off, when people agree, rather than trying to figure it out on the back end when, in theory, there's a problem or an issue that's been raised, and now you've got something to work out and it's contentious, harder to figure things out at that point. Okay, so we'll start with limited partnerships, right? So sole proprietorship and general partnership are the defaults. Limited partnership is sort of the first choice that you can make. And as a practical matter, for a startup, you're likely not going to organize as a limited partnership, but it may come into play with other things that you're doing. So and it helps explain some of the LLC and corporation setup as well. So we'll work through this a little bit. So limited partnership is something that you have to elect. You have to form an entity, file with the Secretary of State. It's not a corporation, so it's called unincorporated, but you have to file a certificate telling the state, hey, I formed a limited partnership. And the way that this differs from a general partnership is you still have a general partner, but the rest of the people that are involved are called limited partners. So the general partner, just like a general partnership, has the unlimited liability. The limited partners, as their name implies, have limited liability. And so what that means in practice is the amount of money that they contribute to the company is what they have sort of put up as their collateral, as it were, for the company, right? That's what's at play. If you've organized as a limited partnership and I sue the partnership, I can't go after the limited partner's house unless that's part of what they've contributed to the entity. They're insulated by the entity through this process and by going through the steps of forming an entity. Limited partnership has some other limitations to it. the limited partners cannot be actively involved in running the partnership. You can have maybe some approval for the LPs on big ticket items, like if the general partner decides to sell all the assets of the business, right? That's usually something that the limited partners would have to approve as well. So you can have those sorts of things, but they are not allowed to participate in the day-to-day management. Or if they do, then they are treated as general partners, and so they lose that liability protection. The way that this comes up most often sort of in the startup space is like a venture capital firm. They often organize as limited partnerships because they want to take the investor's money, and then the general partner wants to actually run the fund. And so this setup works well for them, right? The general partner runs the fund, actually makes the decisions, makes the investments, and the limited partners are sort of prevented from being too involved or interfering with the general partner's management of the fund. So that's the main spot that comes up sort of in this context.
Justin, there's a question in the chat from Josiah. Is the general partner typically the majority owner? And is the general partner typically an individual or another limited liability entity?
Yes, those are great questions. Those are sort of the next level. So that's great. So the general partner, because they have this unlimited liability, and people know that and have developed these things over the years, that's almost always going to be some other entity. So you'd have a GP of a limited partnership. That's likely not going to be an individual. That's probably going to be an LLC or maybe another LP. These things can get fairly complicated, and there's layers and layers, but it's almost always going to be some other entity, because the people that are running, venture capital funds, they know full well that the general partner has all this liability, and so they don't want to take that on as individuals. They want to isolate that in some sort of entity. So that's typically how that works. What's the other question? Majority owner. General partner is often not the majority owner. There's some differences between California and Delaware in this regard. The thought is that in California, a general partner has to have at least 1% interest, but in Delaware, they've specifically allowed a general partner to have a 0% membership interest. So oftentimes they are in control and run the fund, but literally have no membership, financial interest in that part of the entity. Don't feel too bad for the VCs. They've got other mechanisms, and they'll get paid, up and down the chain in other spots, and have management fees and carried interest and other sorts of concepts. But they're often a very small percentage owner, if anything, right? In Delaware, they can be 0. Good question, so.
Okay.
Okay, so next we've got corporation. So this is the entity that most people are the most familiar with. It's a much more formalistic entity. There are defined structures to this thing. Again, this is not a default. This is something that the people that are forming the entity have to go to the Secretary of State, file a certificate to form this entity. In California, it's the Articles of Incorporation. In Delaware, it's a Certificate of Incorporation. Same thing though, just different phrasing. So you file that with the state. You adopt bylaws to help run the company, and then all the stuff that we talked about, the management, the control, who's supposed to get what rights if the entity is dissolving, or if somebody has to leave and can't participate anymore. All of those things are going to be added on through additional documentation. So you've got bylaws as sort of the base level. You can have voting agreements, buy-sell agreements. You can have some vesting structure within stock purchase agreement to set up the company. But this is where you start to see some of those things take shape, and you can build out things much more specifically and the way that you want to. You don't want to default into, like we talked about, the GP or sole proprietor scenario, because you're missing out on all these opportunities to set things up sort of the right way. So in a corporation, the sort of three different buckets that people fall into are either a shareholder, a director, or an officer. And these are distinct roles and responsibilities. Shareholders, for the most part, own the equity of the company and get the profits of the company. But their day-to-day, not even day-to-day, their only real management function is to vote for the board of directors. And then the board of directors run the company from a sort of 10,000-foot view. They would say, right, so for my widget production company example, the board of directors might say, we're operating in California. We've got a warehouse here and we're selling to people here in California. We want to expand our operations to Nevada. So they'd sort of make that as a declaration. And then part of the director's other job is to appoint officers. And those people are the ones that carry out the day-to-day mission of the entity. And so those folks would be, going to Nevada, finding a new warehouse, signing a lease, hiring employees there, carrying out all the things that are entailed by, let's move to Nevada or expand to Nevada. Those are the ones that are, the officers are the ones that are actually making that happen. And so these terms are things that people are familiar with. People sort of understand what shareholder means. Director and officer, sometimes people get that confused a little bit, but those are things that people talk about pretty frequently and have a decent understanding of. And we'll talk about it a little bit more down the road in another slide and section here, but it's important to keep those things distinct. Oftentimes, especially in a startup, it could be that, if you're doing a startup on your own, you're the sole shareholder, you're the only director, and you're the only officer. You fill the three statutory positions of president, secretary, and treasurer. And so it becomes important to follow these sort of formalistic silos that these things fall into. Like I said, we'll talk about some of the issues with that a little bit more down the road.
Justin, there's a question. Justina wants to know, are officers part of the board of directors?
No. So those are distinct. Well, the position of officer is distinct from the position of director, which is distinct from shareholder. Those three distinct positions can be filled by the same people. So there's a little bit of nuance there, right? It's not as if the shareholders have to be different people from directors who have to be different from officers. So it is distinct, although it may be filled by non-distinct people, if that makes sense.
But I'm not sure if this is exactly her question, but an officer is not automatically part of the board of directors.
Correct.
But they can be elected to be on the board of directors.
Correct. But yeah, and there's what's the phrase? Ex officio, I think or something like that. It's some Latin that lawyers love. You can have director positions that are filled by someone by virtue of them being, the CEO. They may also be a board member, but that is a way to fill the director position. That doesn't mean that as an officer now they're part of it. You're still putting on the different director hat. It's just a way to fill out the board of directors.
Okay, thank you.
Yeah. So as we talked about here a little bit, the corporation has been around the most. This is often the form that a startup takes, and so there's a lot of familiarity with a corporate structure, the terminology that's used. We work with people all the time that are talking about a partnership or an LLC, and they're talking about their shares in those entities, which don't exist, right? That's a corporate term. So that's something that sort of permeates throughout these discussions. And there's nothing really wrong with that, right? You just want to make sure that you're talking about the right stuff. But part of what that, how that reverberates out through this entity selection discussion is that if you're talking about a corporation, usually, a venture capital firm will have familiarity with both and they'll understand some of the nuance. But some other less sophisticated investor may not understand those differences. If you're giving equity to some of your employees or service providers, they may not understand the differences between a corporation and an LLC. And so there's this perception which sort of morphs into a reality because that's how people operate. That a corporation is easier to understand, easier to transfer those interests, and so it's sort of a perpetual thing where corporation's been around, people understand it, and so they like it more, and so that sort of feeds into itself and makes a corporation somewhat of a preferred structure in that sense, just for its historic use, people's understanding of it, and then on the back end, the ability to explain it to the next guy what it is that they're getting. So there's that perception for a corporation. So a limited liability company, LLC, is the next option here. And this is a relatively more recent structure that's been brought onto the scene. They are generally more flexible than corporations. So it's still something that you have to form. You file articles or a certificate with the Secretary of State. So it's an active thing that you have to do. And then you'd have an operating agreement that governs how it's run and structured and managed. That operating agreement, you can separate things out, but that often takes the place of a number of documents in the corporate context, right? The operating agreement is sort of a combination of bylaws, a buy-sell agreement, voting agreement, all those things wrapped into one. It's often how that goes. Part of the reason for that is the flexibility that you have with an LLC. So in terms of terminology, LLC is owned by members. Those are sort of the functional equivalent of a shareholder or maybe a limited partner, perhaps. And you can run your LLC to be either member managed or manager managed. Member managed means that the members run the company. And so that would be sort of the functional equivalent of a general partnership, right? You've got some people that own the company and they run the company. The benefit of the LLC structure is that they have limited liability, right? Limited liability company. So it has benefits above and beyond the general partnership, in that it insulates the people that are running it from that uncapped liability that a GP would face. The other option is to have a manager managed LLC. And in that context, it takes on a little bit more of a limited partnership form, in that you've got a manager that acts as the general partner. You've got limited partners that are more, usually they're contributing financially but aren't participating in the day-to-day. But again, the benefit of an LLC, and part of the reason that it was created, was to again have that liability protection. So a manager in an LLC still has liability protection. They don't have unchecked liability like a GP would in an LP situation. And there's also more flexibility than a limited partnership, in that the members, even if it's manager managed, they can participate much more than a limited partner would be able to in a limited partnership. And that makes sense, right? Because if you've got the ability to have limited liability and have the members run the company as a member managed entity, when it's organized as a manager managed entity, there shouldn't be a problem with them having that involvement and control. And so what that comes down to is just it becomes more of a creature of contract, and you're looking to the operating agreement to see how things are set up, who has what rights and what responsibilities in different situations. And it gives you much more flexibility. You can set things up a little bit more, sort of how you want to in that management context. In addition to that, there's a lot of flexibility in LLCs in terms of how taxes are allocated, how distributions are made, those sort of financial things. And that's a big benefit to LLCs. It does complicate matters quite a bit. And I think people get out over their skis pretty quickly in terms of making those allocations and not really understanding the tax ramifications of those things. And so that's, an option that gives you some flexibility, but an area that you can potentially get into trouble and create issues that you didn't realize you were creating. Okay, I'll talk about that a little bit. So we talked a little bit about the flexibility here, and we have to weigh that a little bit versus the familiarity and understanding with a corporation. So for an LLC, just taking sort of one example that's easier to wrap your head around. In a corporation, oftentimes they will provide service providers with, employees with incentive stock options. That's something that people, hear and understand a little bit. Google and all the big companies do that. And so people, read articles and sort of understand that concept. That's not something that you can offer in an LLC. There's no incentive stock options in the LLC context. So you have this flexibility to largely mirror a corporation in terms of how things shake out, but the terminology and some of the tax implications are going to be different. So you don't have incentive stock options for an LLC, but you have what's called the profits interest. So that basically amounts to you take the value of the company as of the day that you're granting the profits interest. So say we've got a $1 million company, and you take everybody that's a member up until that point, and they basically adjust what's called their capital accounts, and they adjust their interest up to $1 million. And then if I'm the service provider, I get a membership interest above and beyond the $1 million amount. And what that does, and how that benefits everybody, is that I essentially am getting there's no taxable event on that transfer, because I'm getting something that's worth $0 sort of by default. We've said the company is worth $1 million, and Justin only participates above and beyond $1 million. So what I have right now is worth nothing. And so, $0 is not a taxable transfer. So there's ways that you can, get people involved, sort of get them equity and work those things through. But like I said, it's not the same as incentive stock options. The taxation and how things shake out are different, and the terminology is different. So it often takes a lot of explanation, both for the company and then for the person receiving whatever the equity incentive is. Some conversations and some education to make sure everybody understands. And even when we've gone through all that stuff, there's other ramifications that may or may not have been intended. So it's like I said, can get complicated, and part of the reason for the default to the corporation is it's a little more well understood. There we go. Okay, so like we talked about, there's some other factors that play into what type of entity you want to form and how you want this thing to be organized. So from a state law perspective, we're going to talk mostly about corporations and LLCs now for the most part. But from a state law perspective, all corporations are corporations. They have the same limited liability. And then, LLCs are LLCs, right? That's ownership and management structure, and they have limited liability as well. The tax issue comes into play when you make, for a corporation, you would have to make an S election, it's called, to have something different than the default, which is called a C corporation. And those are just references to Internal Revenue Codes sections. So a C corporation has what's called double taxation. You've got tax when the company makes money, that gets taxed as income to the corporation. And then when money is distributed out of the entity, usually via dividends, those are taxed as well. So you've got those two layers of taxation that people talk and complain about. And that's the default. If you just form a corporation and don't do anything else, operate your business and then file your taxes, you're going to be a C corp. If you want to do something different as a corporation, you can make this S election. And there's some other fees and taxes that go with this. But for the most part, then that becomes what's called a pass-through entity. And so there's no tax at the corporate level. The profits of the company are passed through to the individuals as individual shareholders, and then they're taxed at their own personal tax rates. So you don't have that double taxation. For LLCs, let me see, before I move on here, make sure I'm covering all my stuff. Okay, So LLCs and partnerships, of course, the default is they are taxed as partnerships, which similar to an S corporation that has pass-through entity status. So same sort of concept, right? You don't get taxed at the entity level. Everything passes through to the equity holders. They get taxed at their own particular rate. The difference between there's some differences between an S corporation and an LLC taxed as a partnership. Besides the organizational structure, the taxation is going to be a little bit different. And in all these things, right? So I'm a general corporate attorney. I know some stuff about taxation issues. Usually it's, the sort of the top level, and then any follow-up questions there, there's exceptions and exceptions to the exceptions. So pretty quickly we need to engage our tax experts. But the basics of it are that for an S corporation, you can't make the same special allocations that you can in an LLC. It's, one class of stock and everybody has to be treated the same. You can't move profits and losses around between people the same way you can with an LLC. The treatment of distributions and property coming in and out of the entity is treated different. Again, that gets a little bit complicated, but something to potentially consider, the way that those things are taxed. The one other area of caution that I would say here is that, tax is obviously an important issue and something to consider. But, we're talking about these things in a startup context where, oftentimes you're not making any money for years and years and years. Even when you're doing these big raises, oftentimes, these companies aren't profitable. And so it's important to think about and, be aware of these things, but not necessarily let the, taxation tail wag the dog, as it were, on this. And, make sure that you're considering all these things and, weighing the tax issues appropriately. Not overthinking it and saying, well, what happens when I do X, Y, and Z? Because, the chances of that happening or the timeline on that happening are much further down in the future. So that's something to remember in all these things as well.
Justin, are you going to talk at all about, you talked a little bit about that investors like corporations, but it, doesn't mean you have to be a corporation. Are you going to talk about that in relationships like S Corp and C Corp, which type investors prefer?
Yeah, that'll basically be wrapped up in this.
Okay.
Yeah. So besides those taxation issues and the differences between C Corp and S Corp are just a tax election. So yeah, that sort of leads into Laura's point here. So if the S Corp has, these tax benefits, why would anyone ever want to be a C Corp? You get taxed twice, which obviously nobody wants. So why isn't everybody an S Corp? Well, to take advantage of those tax benefits, there are some limitations and things you can't do. So an S Corp is not allowed to have more than 100 shareholders. So if you're a startup and, the goal is to do an IPO, somewhere along the way, you're going to get over that number of shareholders. And so that's an obvious problem there. You're going to break your S Corp election and you're going to basically revert back to a C Corp once you break any of these rules. And so that being sort of the goal for these sorts of things, that's a limitation. The types of people that can, the types of investors that can hold shares in an S Corp is limited. It's basically individuals, trusts, and then certain type of other entities, but basically, corporations and LLCs, for the most part, can't hold an interest in an S Corp. And so depending on how the investors are coming on board, they're limited in that aspect. Usually a VC wants to have their fund or some sort of entity involved, and that can be a limiting factor for an S Corp. And of course, when those people have the money and they want to invest a certain way, then basically, the way this usually works is you have to bend a little bit to be able to take on their cash. Another detriment or limitation on a S Corp is they can only have one class of stock. So everyone has to be sort of treated equally. In the investor scenario, they're likely going to want, if they're an institutional investor coming in at the Series seed round or, Series A something, they're going to want preferred stock. They're going to want rights above and beyond the common shareholders. And that's not something that you can accomplish with an S Corp. There's a couple of other restrictions. S Corps can't be insurance companies, they can't be foreign corporations, and some other miscellaneous things. But these are sort of the big ones that prevent that from being a viable option for a startup that's seeking, to go the traditional route of taking on investors and getting VC money and expanding that way. And we'll talk a little bit later on about what these mean and how permanent these are and how to fix things if you've done one or the other, that sort of stuff. Okay, so we've talked a little bit about the structure, the management, the way these things are all set up. And so we've got, the corporations are set up with these corporate formalities, right? We talked about how formalistic a corporation is versus an LLC, right? The corporation, again, has the shareholders, directors, and officers. These may be the same people, but these are all different hats with different rights and different responsibilities. And in the corporate context, those things become very important because part of the reason that you set this up, besides the management, is to have limited liability. And if, particularly if the ownership and control group is a small group, right? If it's maybe just one person or if it's just a couple of people that fill all of these roles, there's some difficulty in blurring some of those lines, right? Sometimes you may say, oh, I just signed this lease for the company and I just signed my name at the bottom. Well, that means you're entering to the lease, in your personal capacity rather than as an officer on behalf of the company. And so you're not respecting what's called the corporate formalities. And the issue with that is, so to sort of bring it back to the beginning, is when, you sell your widget, it's cut my hand off and I'm suing the business. I sue the company because that's who's making the widgets. But then, it's a startup and you guys don't have much cash or assets to go after. And so, we're going to be, this is getting out of my wheelhouse, but we do discovery and I look at your books and, I find out certain things and I see that, you guys are signing things incorrectly. You're not holding regular meetings. You're not doing annual meetings, appointing the directors, appointing the officers, making sure that when people resign, somebody replaces them, observing all these corporate formalities. And in particular, one of the bigger issues with these things, because funds are such a big deal, is sort of commingling funds. Right? Oftentimes, some corporate bill will get paid from a private account, or vice versa. Money's moving in and out a little bit willy-nilly, and sort of blending those bank accounts and not documenting, those things as a contribution, as a loan to the company, as a distribution from the company to the shareholder. Not formalizing those things and making a choice leads to, again, not respecting the corporate formalities. And sorry for that diversion there, but to bring that back to the example, so when I come and sue the company, they're going to say, well, we don't have much money and we're a startup, and so we have this entity, and so our liability is limited to what's in that company. And basically, what I'd say is I make an argument to pierce the corporate veil, it's called. And what that entails is basically me saying, yes, you have this entity that's supposed to be a separate thing that's respected as its own deal, but you aren't treating it as a separate entity. And so now I don't have to treat it as a separate entity. I should be able to sue the company and then sue you as individuals because you're not treating it separate. So why am I required to treat it separate? Is the basic premise there. And obviously that's a huge deal because that's, a good chunk of the reason that you set up a company like this is to limit your liability and prevent these sorts of issues. I like to bring up the example of Mitt Romney when he was running for president. There's that clip of him saying corporations are people too. And so this is what he's talking about, right? The corporation or the entity is supposed to be separate and apart from you as an individual. It's supposed to be respected as its own thing. And that's an important part of this concept. And so it's good to keep that in mind as you're trying to operate the company. If you're running for office, maybe not the best thing to say, because obviously he didn't win. But in this context, it holds true and is good advice. Okay. So there are corporate formalities for an LLC as well. But as we talked about, those lines are blurred a little bit. You don't have the distinctions between sort of the shareholder, director, and officer. Those are blended into the members and the managers a little bit more. And so, you're still not supposed to commingle funds and that sort of stuff. But the day-to-day operations, essentially there's a little bit less scrutiny put on those items because an LLC operates different than a corporation. So it's something to consider for LLCs as well, but a little bit easier in that context. So for fees, a lot of similarities in terms of fees. For California, C corporation has a $800 minimum franchise tax. LLC is the same. So that is basically for the privilege of doing business in California. An LLC and a C corp give the state $800. If you don't, they'll basically take away. You're no longer in good standing, is sort of how it's phrased. And so you still exist as an entity, but you're not in good standing with the state, and so you lose the privilege to do business in that state. Which means that if you entered into a contract when you weren't in good standing, people can revoke it, and it causes all sorts of issues. So there's some mechanisms behind that enforcement. Similarly, for an S corp, there's a minimum of $800 franchise tax, but it's the greater of 1.5% of the company's net income or the $800. So for an S corp, it sort of depends on what you're paying. So that's where it gets a little bit blurred for an S corp. There's not the two layers of taxation, but your franchise fees, your franchise tax is based on a rate like that. So it sort of amounts to something similar, although it's just 1.5%, so nothing near the corporate tax rates. Okay, so all of this stuff has been sort of in the general context. I think I mentioned it earlier, or at least I intended to, right? These are all creatures of state contract. So if you decide, hey, I'm going to form a corporation, you go to a Secretary of State and you go to a specific state. Here in California, we often use California, obviously, because that's where we're doing business. And then Delaware is the other option. And so deciding where to incorporate makes a big difference. There's the first sort of base layer of that decision. And California has a $800 franchise tax. Delaware has its own taxing system, somewhat similar. Theirs is based on some math, basically, but they have taxes you have to pay there as well. And so you're deciding where to incorporate, and that's a big consideration. At least starting off, that's a pretty big consideration. Do I want to incorporate in Delaware like all of these companies seem to, when I would have to pay Delaware tax? And then if I'm sitting here in California, hiring California employees and all of that, I'm going to have to register in California as well and pay, file stuff with California, pay California taxes and fees. Now I've got two states I have to worry about, not a huge administrative burden, but particularly when you're starting off, there's a million things to do. You have no money. And so adding that extra layer of, administrative burden really is something to consider. In California, obviously it makes sense that we operate here in California because to do business here, you have to be registered here. So might as well incorporate here. The reason that people go to Delaware so much is Delaware has sort of made itself a business-friendly state. They've got years and years of business-friendly statutes. And then because a lot of people went there to incorporate their business, they have lots and lots of judicial decisions that explain their statutes and work through a bunch of the issues that people have. So they've got basically through the statutes and the judicial decisions. They have a more robust corporate law. Their judiciary is used to dealing with these issues because people go to Delaware basically to form a company. So they're more well-versed in these things. And so people like and prefer Delaware for those reasons. And it's similar to a corporation, right? It sort of just builds on itself. People like Delaware because it works well, and then Delaware works well because people go there. So it builds on itself that way. And when you're at some point, usually it's maybe a Series Seed or a Series A round, somebody's going to require that you move to Delaware if you're not there already, because investors are familiar with it. There's a little bit more flexibility in terms of reducing the fiduciary duties, the company's ability to indemnify its officers and directors is a little bit greater in Delaware. And so there's some benefits for Delaware in those contexts. And again, like I said, there's just that familiarity. People understand and know Delaware much better. So often you'll see, if you're in California and you're getting a California VC to invest in you, those folks obviously understand and are familiar with California law. But if you're getting an out-of-state investor, this summer we did a deal where we had a California company, but there was investors from North Carolina and Tennessee, I think, sort of in that region. And we were already a Delaware entity, headquartered in California, but already a Delaware entity. And so, they don't worry about, well, I don't understand California law and whatever. We've got our neutral Delaware jurisprudence that's going to help everybody understand how these things work. In the past, there was some benefit to Delaware in that you could essentially, you're supposed to be filing certain things, and if you didn't, you just had to pay a fee. So there was a little bit more ability to remain anonymous in Delaware. It's not quite the same as it used to be, although as a practical matter, it's still easier to look things up and find out information about companies in California than it is Delaware. The California Secretary of State's website tells you more about the company than Delaware does. But in Delaware, you can basically get there. You just have to pay some fees. So there's that extra step. But that's something that people sometimes consider. They want to have some anonymity, either as the investor or somebody that's involved with the company. And so that's something sometimes people consider. The other way to handle that, of course, is to have some multiple layers of entities, and you can have sort of obfuscate things that way. That's something that people have brought up in the past as well. All right. So we've got sort of just what I've called other considerations. We touched a little bit on fiduciary duties. In California, the duties of corporate directors are set out in the California Corporations Code. And there's some limitations on how much you can reduce those duties. You can go above and beyond that in Delaware and make things a little bit more, it's just a little bit more flexible in Delaware, I guess, is the best way to put it. And so you can change things that way. In a corporation, majority shareholders, or what's called controlling shareholders, which is sort of a technical term, but basically those, if you're in charge of the company and can outvote other people, they owe certain fiduciary duties to minority shareholders. So that's something to consider as well when you're setting up an entity. Is how are these shareholder interests delineated? How is this broken down? In a LLC, you've got managers that we talked about, and those people have the same fiduciary duties to the members as partners would in a partnership. They don't have the same liability that we talked about. They don't have that general liability, but they still have to basically put the interests of the company above their own personal interests. Members wouldn't necessarily have that fiduciary duty unless it's a member managed entity, and then it sort of shakes out the same. And again, those fiduciary duties can be limited and worked around a little bit in the agreement, although there's more flexibility in Delaware than California. Yeah, so we talked a little bit about at the beginning, LLC use is prohibited for certain professions and professionals. So, professional corporation is the only thing that like a medical service provider can be. They can't be an LLC. There's other regulated entities that fall into that as well. Usually not an issue with these startups, although, in theory, there could be something that comes up there. And then the last thing, I've just sort of called it a timing issue. And this gets down to, sort of the, at the formation, right, you're going to make some decision on what type of entity you want to be. And so there's sort of that time, and then there's down the road, things have changed in one way or another. And does the entity that I chose at the beginning, does that still work for me now? And so one of the things to consider here is the timing of what you have anticipated, right? If you're forming a startup and it's based on, some scientific research and you want to form an entity, but, you've got to do a bunch of work for 5 years before you talk to anybody else about, starting a product and bringing in money to expand, right? You want to form this entity because there's a couple of you, but you're just going to be, working away in your workshop for years and years. It may make sense to basically ignore what investors like, which is a Delaware C Corp, and say, well, we're going to be operating for 5 years by ourselves, in California. So we're going to be a California LLC until we get to that point, until we decide, hey, we're going to take on some money, and then we'll deal with it at that point. And it's a process. You have to file documents, you have to get consents and approvals, and there's things to do to go from an LLC to a corporation. But that's possible. You can make that work, and it's pretty routine to do that. You can go from a California LLC to a California corporation, and you can what's called redomesticate. You can move the jurisdiction of organization from California to Delaware. That can be a little bit harder, but it ends up being just a two-step process. You can do that. You can sort of fix or change what you decided to do at the beginning down the road. So that's something to consider as well, right? If you've got, hey, we want to form this entity and we've got VC people talking to us about giving us money next week, probably doesn't make sense to organize as an LLC. Probably just want to do it as a Delaware Corp and skip those other steps. But there's no issues, and like I said, maybe it makes sense to set it up one way with the anticipation of changing it down the road when the need arises. And that's in that context, that's particularly true, or particularly less painful, because as part of taking on that investor money, they're going to make you amend and restate. Even if you were a Delaware corporation to begin with, they're going to make you amend and restate and basically redo your articles, set things up differently to take on their money and to take on their preferred interest. And so it's not as if you're saving maybe a half step, but you have to do a bunch of reorganization anyway. And so that's always a good time to take care of that. All right, so that's a lot of information, and I feel like it's just me talking and talking and talking, which I don't like doing, and I assume people don't like hearing too much. But thank you very much for letting me take some time to talk about entity selection. Hopefully it was good information, and I see some stuff in the chat, so I assume we'll cover some of those questions we didn't get to.
Yeah, so it's our official Q&A period. If you have a question, I think we're actually a small enough group that you could go ahead and unmute yourself and ask your question. And we'd like it if you unmute yourself, if you also show your video, that's helpful. Also, I want to say that we will be sending you a link to Justin's slides, probably not today, but before the end of the week. So there was one question in the chat from Josiah. Josiah, do you want to ask that?
Sure. Hey, I'm Josiah Prendergast. I actually work with Justin at Weintraub. I'm on the business litigation side. So This is helpful for me to kind of understand what goes into the setup process when partnership disputes come my way. So Justin, the one question that I had is how often do you see the modification of fiduciary duties arise as a consideration when choosing or setting up an LLC? Because I know California and Delaware have different laws in terms of how much you can vary the fiduciary duties of members.
Yeah, so that comes into play all the time. It doesn't come into play usually at formation. It's almost always at the investor stage, because we talked about the different things, right? You don't want the tax tail to wag the dog, right? Same sort of thing there. Usually those sort of considerations are outweighed by other things when, it's me and you forming a business here in California. We say, I'm not worried about that right now. I don't want to pay the extra tax. I don't want to have to worry about doing that, all this admin stuff on top of things. But that's something that comes in all the time with the VC money at that stage. They say, well, this is our preferred jurisdiction for 50 reasons, including the ability to limit indemnification. I'm sorry, expand indemnification, reduce fiduciary duties.
All right. Zayad, do you want to ask your question?
Sure. I guess I got some answers in the chat, so I don't know. I guess I can still ask it, but I was asking about the difference between directors and officers, basically. I know you kind of touched on that a little bit, but I don't know if you can elaborate a little bit more on that. And I had another question, and I don't know if this is okay to ask or if there's any conflict of interest or if you even provide the service, but any recommendations on good accountants, that understand business taxes very well in the greater Sacramento area that you can refer me to?
Yeah, so I'll do the sort of inverse there. CPAs, there's a bunch of firms in town that we work with. It sort of depends, similar to law firms, right? It sort of depends on where you are in the process, who makes sense to be talking to. If you're looking for some easier basic things, probably doesn't make sense to go to, Price Waterhouse. Solo practitioner or smaller firms, probably better. We sort of operate in the mid-sized space. So those tend to be the firms that we work with. So we've got a lot of recommendations there. And then some recommendations for smaller firms. And I can send those, or we can sort of chat offline. Because like I said, it depends on where you are in the process, what makes the most sense for you. In terms of differences between officers and directors. So yeah, remember this is limited to corporation where these positions come into play. Directors are selected by the shareholders. And so there's usually an odd number, 3, 5, 7 directors, something like that. And those people control the company from what I call the 10,000-foot view. So they would say, as sort of the example I used earlier, they would say, we operate in California and we want to expand to Nevada. And then they charge the officers with actually carrying that out. So the directors are a little bit more, you think of them as like the idea people. They say, okay, we've presented with this opportunity, or we think it's a good idea to change how we're operating, and this is what we've agreed on doing. And then the officers carry that out. So to actually, expand your operations to Nevada, you would, find employees there, sign a lease, work with manufacturers to either manufacture something for you there or deliver to Nevada, those sorts of things. And that's the officer's role, is to actually carry that stuff out. So that's how those things are different.
I see. So it's, I'm sorry, go ahead.
Oh, sorry, I have a question. So can officers and the employees be the same person?
Officers and employees?
Right, the person who carry out versus the board of directors, can they be the same person?
Yeah, so directors and officers are different roles and responsibilities, but they can be filled by the same person.
Okay, thank you.
Yeah, and oftentimes when you're starting up, if you're working on something on your own, there's only one person to fill that thing. It's just you working by yourself. So you're the sole shareholder, you're the sole director, you're the treasurer, you're the secretary, you're the president. All of those. Yeah.
Justin,
Go
I'm
ahead,
sorry.
Zach.
I had some connection issues, so I heard the second answer, the whole answer, but the first answer to the accountant, the referral thing, I didn't hear. If you don't mind.
Oh, yeah, I was just saying it sort of depends on where you are in the process and exactly what you're looking for. So we've got people we can recommend, but probably easier to connect offline and see what you have going on to see who makes the most sense.
Sure. So do you mind? Should I email or call, or what's the best way to get a hold of or get in touch with you?
Yeah, either one. Email is probably easiest. Is my screen still up there? I think my email's on there. I can put it in the chat.
Yeah. No, I see it. Yeah, that's fine.
Okay.
Thank you.
Yeah.
Hi there, Justin. This is Kulvinder Singh asking about state of incorporation. Can you say anything if you've done it dealing with Nevada or Wyoming corps?
We have. So we are a California law firm. So for the most part, people come to us because there's some sort of California connection. Either they're, here in California, or it's somebody from another state that's coming here to do business, or buy a company here or invest in a company here. So usually when people are coming to us, there's, like I said, this California connection, and there's some supposed benefits for Nevada, some supposed benefits for Wyoming. I found that in practice, those are outweighed by the administrative burden of, okay, I've formed a Wyoming corporation that has, I think Wyoming has some of the anonymity protections that people have liked. But if I'm a Wyoming corporation and I'm sitting here in California and I'm operating the company here, I still have to register my business here in California, which means I have to disclose my information to the California Secretary of State and operate under their sort of provisions. So you sort of lose that by virtue of being here in California, and it ends up being sort of moot. So we have worked with those entities, and sometimes there's a reason to be there or not. If Nevada in particular, right? If you can separate yourself from California, and maybe you live in Incline Village and you're operating everything in Nevada, then there's benefits for sure, right? Avoiding our lovely state and their regulations and their taxes, right? That's something people look for. But it tends to be, for the most part, you've already got this California connection by virtue of coming to us, so it often doesn't make sense to worry about Nevada and Wyoming.
So Chris, did you have any input on that? Because this was new to me when I first came across people saying incorporated in Wyoming or Nevada. I thought it was just Delaware, what we learned in law school. Chris?
This is Chris Schultz. I hadn't raised that question. I don't have any information to add, though. Thanks.
Okay, thank you.
Justin, I have a question.
Sure.
B corporations. What can you? They were kind of a rage a while ago, a way for a corporation to have a. Well, as I understood it, they didn't have to make all their decisions based on profits to shareholders. That they could also make decisions based on, say, a social cause or something of that nature. Can you talk about B corporations?
You mean public benefit corporations, Laura?
No, so a benefit corporation is different than like the nonprofit, public benefit aspect that you're talking about. B corporation is sort of, I think it's sort of a separate thing. We don't deal with them very much, and I'll sort of explain why. But the concept, like you were saying, was that they don't have to, they can consider things like, the environment or how we treat our employees, or, sort of ESG is sort of the new version of that. They can consider those things in addition to, shareholder profitability. And that's, the understanding, at least, or how things are put into practice has been that, the way the world works now, people will look at those things regardless. So if I'm a regular corporation, I can make decisions like I'm going to do something that is more beneficial to the environment, even though I'm going to make a little bit less money. And you can justify that by saying, if I did something bad for the environment, I'm going to get sued. My projects are going to get held up by the EPA and these environmental groups. everyone's going to hate me, and now my company is not going to be doing well. And so you can basically approach things with that sort of B Corp mindset and still operate that way without having to go through the rigmarole of establishing it as a B Corp. And so that's often what we see and how we approach things. I don't know, we don't do a bunch of much like government contracting, so I don't know if they have any preferences, like a woman-owned corporation or a veteran-owned companies have some preferences with government contracts. I don't know if B Corps get that sort of thing or if there's some other benefit like that. Yeah, we don't really see or deal with them too much.
Okay. Anyone else have questions?
Just looking through here. So it looks like Claire, you had another one about, I don't know when this all came in, the timing. Claire had another one about Delaware LLC. Did you want to just ask that?
Yeah. So I have a Delaware LLC, and we have 2 members when we founded this. So me and my co-founder, after 4 years, she decided to quit. She doesn't want to get involved anymore. And we are working on the separation agreement. But at the same time, I was wondering about the entity, what's the best way, whether I can. Yeah. Do I still keep the Delaware LLC, or do I change to S Corp? Because we are thinking probably we should get investment when the time comes. So that's something in my mind, and I'd like to hear your advice.
Yeah, so there's, like we talked about, there's a lot of considerations that go into that, right? There's tax, there's operational. You know, it's a little bit probably too specific to give you like a, this is what you should do sort of answer. But one thing to maybe think about is, I intended on touching on this, whether or not I highlighted it or not, I'm not sure. But an LLC by default is taxed as a partnership.
Okay.
If it's a single member partnership, then it's usually a disregarded entity, and it's got slightly different tax implications. And I don't know if you can do this as a single member LLC, but in general, an LLC can be taxed as an S Corp. You can make an election to do that. The fact that you're going to be the sole owner maybe complicates that. That's something I'd have to talk with my tax folks about. But the point being is you may be able to sort of keep the entity as is and get some of the benefits of the S Corp taxation if that's better for you. But like I said, probably a little more analysis than we can break down here without some follow-up. But yeah, it's a good example of a number of the issues that we were just talking about, right? And the good and bad thing is that there's usually some complication and a variety of factors that play into these things. We have a little bit of a defined sandbox to play in, but keeps things interesting because there's always some nuance to these decisions that we have to work through and think about. So keeps my day interesting.
Thank you.
Yeah.
All right. Do we have any other questions? Let's see. Robert Sison says, where is a site to review sample bylaws, articles of incorporation, etc., for California and Delaware C Corps and equivalent for California LLC?
I don't know of a good one for a California LLC off the top of my head. NVCA has some good, this is really more for when you're taking on venture capital money, but they have some model legal documents that would be good to look at. They're not necessarily the best starting point, but they'll give you some idea of what investors would be looking to implement and work with. Put that in the chat there. And then I think see the best. Oric, which is a large law firm, they have some form documents that can be pretty good. let's see where this is close enough. I'll give you a link to that as well. Sort of a word of caution with these. There's, like I said, there's some familiarity with corporations and some of these terms, and we've explained some stuff, but with startups, one of the things that we do pretty regularly is there's a bunch of, it's basically a decision tree, right? You've decided to do this and not do this other thing, and you've gone down, and now you are where you are. And one of the things that we often do is work with people that have formed their own entity, often through LegalZoom or something, and they've made some choices that they didn't really understand what it meant or why to make them or not make them. And then we, help them unwind or fix that in some form or fashion. So these are things to review, but I still definitely recommend talking to an attorney to make sure that you're, fully informed and making the right decisions for the right reasons. Because I think the good and bad thing about the internet is there's a ton of information available, and these are good places to start and good forms. But I do this stuff all day, every day, so I know what stuff matters and what stuff you can delete or not worry about in certain situations. And you guys don't necessarily do this all the time. Maybe never if you're I don't know, software engineer or something, you haven't dealt with this before. So it can get complicated, and you can sort of make those incorrect decisions pretty quickly and easily. So there's there's the info. Don't mess it up.
One thing I'd add on, if you're looking at California LLCs, one thing to be aware of, especially looking at templates, is California in 2014 entirely changed their LLC structure of laws, and then even control between members has changed again in 2016. So a lot of the stuff that you'll find out there may not have been updated for that. So that's another reason that just working off of a template that you find online may be a good starting point, but there are a lot of things in terms of statutory default rules that you want to be aware of and look into.
Yes, that's a great point. We get that stuff pretty frequently where it's the Beverly Kalea Limited Liability Company Act or whatever the old name is. And, it's sort of the first indication that, okay, this is a form they got from somewhere, and, that doesn't apply anymore. That's not the current act. And so sort of to modify and expand on those 2 points, I mean, this is, again, a good place to start. I wouldn't recommend necessarily going through it and working it all through and then taking it to your attorney and saying, this is fine, right? That's something that we have a hard time with, is working off of some form that you pulled up somewhere and modified, or something that they just found online. Oftentimes it's easier for us to start with the forms that we're used to working with, and can do that much more efficiently than modifying something you found. So yeah, just talk to an attorney early and often. I know it's sometimes difficult for startups because attorneys aren't necessarily cheap, but it's important, and it helps. I always say you're going to pay us now or later. Pay us to help plan it or to fix it later on. So either way works for me.
All right. Do we have any other questions? All right. I'm just gonna, we don't have a lot of people left, so I'm just gonna post a few links in the chat and talk about those as we wrap up. First, Justin, thank you so much for teaching today's workshop, and this will be available probably sometime next week. The video and Justin's slides will be available on the Startup SAC website. We'll post that as a blog, and then I'll circulate the slides to everyone who registered a little bit sooner than that. This week, if you guys haven't noticed yet, it's Global Entrepreneurship Week, and there's something like 50 events going on in the Sacramento region. So I think I posted a link. I missed that link. I'm going to post a link for the Global Entrepreneurship Week calendar for things that are still going on. And if you like startups, there's a pitch competition happening at the Carlson Center tonight. I think it starts at 5:30, where 10 companies are competing for $20,000 in cash prizes. So that would be exciting. And they have a for-profit track, and then they have a social ventures track which can be for-profit or nonprofit, depending on, what their cause is that they're working for. So the other things I posted in the chat, the Startup Digest comes out every Monday morning, and it is a guide to what's happening in the greater Sacramento region that would be of interest to startup founders. We also have Startup Sac has a community group on Facebook. It's a private moderated group. If you want to join that and be connected with other startup founders or folks who support entrepreneurs, I recommend that. Also, if you are an entrepreneur, the Sacramento Entrepreneurship Academy is currently taking applications for its 2023 cohort. It's the entrepreneurship program that's been around in Sacramento for the longest, I think something like 26 years. So that's all the announcements that I have. Does anyone have any questions before we wrap it up? Okay. Again, thank you so much, Justin. I will also include Justin's contact details in the email I send you with the copy of his slides. So have a great day, and we'll catch you next time.